private prosecution is a criminal prosecution that's commenced by someone other than the state prosecuting authorities. So commonly a private prosecution will be brought by an individual or a corporate or an organisation who perceives themselves to be a victim of crime and who wants to hold the offender to account through the criminal justice process. There are already a number of organisations who actively use private prosecution powers. One of the most well-known is the RSPCA, who privately prosecute those who offend by committing offences of cruelty against animals. And whilst they're still not particularly popular, they are growing in popularity across England and Wales. The reason for that is that in recent years, law enforcement agencies and the public prosecuting authorities have suffered massive cutbacks. And in the age of austerity that we live in, that means they have finite resources to investigate and prosecute certain types of crime. What that means is that for victims of crime, in situations where the state agencies are unwilling or unable to act, private prosecutions might be the only way in which they can access justice against those who have offended against them. Most crimes, with few exceptions, can be prosecuted privately, but there are certain types of cases that are better suited to private prosecutions than others. The features of those cases would be that the offender's identity is known, that the offence has occurred in the UK, that it's a situation where you have the evidence available to you, or it can be secured through lawful means. The types of cases that we are regularly involved in involve victims of fraud, both individuals and corporates, employers who have been the target of dishonest behaviour by their employees, companies who have been subject to the theft of their intellectual property by competitors, regulators who prosecute for those who breach their regulatory regime, and a raft of other scenarios. In any criminal prosecution, there are 5 key stages. Firstly, gathering evidence, making sure that the evidence you have obtained can be lawfully used in criminal proceedings. Secondly, making a decision around the correct charge, deciding what charge fits the crime and being able to demonstrate objectively that it's in the public interest to prosecute. Thirdly, the laying of your informations in court and the continuation of the court proceedings, which at the same time you need to consider disclosure. And that's the obligation on all prosecutors to make sure that material that the prosecutor holds in their possession, which needs to be disclosed to the defendant, can be done so appropriately and in a timely manner. When you get to the conclusion of your trial, the 5th and final stage is sentencing, confiscation, compensation and recovery of costs. And those considerations are around what you should do when bringing the offender to justice and in some cases seeking recovery for your losses. Private prosecutions do involve a complexity that public prosecutions do not. If errors are made at the outset of a private prosecution, often it is impossible to remedy those, and as such, the prosecution fails. In addition to that, any issues with the conduct of a prosecution can have negative costs and reputational impact on the prosecutor concerned. So for that reason, it is most important that if this is a route of action that you are contemplating, that you take advice from a lawyer at an early stage to make sure that you appropriately discharge your prosecutorial obligations. Not all disputes will be suitable for a private prosecution, but in the right case, where the offending involved is serious, and particularly where the state prosecuting agencies are unwilling or unable to act, this is an excellent route for you to achieve justice through the criminal justice process.